Morning in Case 13-483, Lane v. Franks. Mr. Singh?
Mr. Chief Justice, and may it please the Court, Petitioner Mr. Edward Lane alleges that Respondent Steve Franks fired him in retaliation for his testimony before a federal grand jury and district court on a matter that is undisputedly of public concern, the misconduct of a state legislator. Petitioner testified about events that he learned while working, but the testimony itself was not a part of his job responsibilities. This Court should hold that Petitioner's testimony implicates the First Amendment because he spoke as a citizen on a matter of public concern.
To further hold that this was clearly established in 2009 when Respondent Franks fired him. Those holdings follow from a long line of this Court's precedents, which establishes that the First Amendment applies to all public employee speech on matters of public concern, except when the employee speaks pursuant to his official duties.
What if the person who testified had the definite job responsibility of investigating possible corruption in the agency? Suppose that person was something like an inspector general. Would the testimony be within the scope of the person's job duties?
I think it would depend on the circumstances of the particular case, and that would be the exact next question, because the responsibility to investigate by itself does not necessarily also include the responsibility to testify.
Well, wait a minute. What are you doing about the truth-finding function of a trial setting when you're saying or telling people, employees, don't go and tell the truth, because if the truth hurts your employer, you're going to be fired?
Your Honor,
there's something — you can be always fired for some other reason that the employer can point to, under Pickering or otherwise. But what kind of message are we giving when we're telling employees, you're subpoenaed for any reason in a trial, go and tell a falsehood, because otherwise you can be fired?
Mr. Wagoner?
Mr. Chief Justice, and may it please the Court. The Court should affirm the 11th Circuit's decision on the First Amendment issue, but regardless of how it rules, we agree with the United States and the state of Alabama that Dr. Franks is still entitled to qualified immunity.
I still don't understand or didn't understand what it is you're saying.
It depends on the speech.
But if someone is called to testify truthfully about a matter of public concern, and they testify that way, should they be able to be fired under the First Amendment?
Yes, Your Honor.
Really? Well, let's say his job is to investigate corruption.
Where the employee goes beyond that and expresses views, criticizes the school board, and that sort of —
Where did you get this notion that the First Amendment only applies to the expression of views and not to the conveyance of facts? I don't know where you get it from. I've never heard of this distinction. The First Amendment protects only opinions and not facts. I've never heard of it.
Well, Your Honor, we believe that it's a long-time precedent of this Court that speech, certainly in the Hustler Falwell versus Hustler case, where it talked about speech that is close to the heart of the First Amendment.
And so you're requiring the government employee in this case to be a better analyzer of Supreme Court precedent than the 3 11th Circuit judges.
Pursuant to your official job duties.
Thank you, counsel. The case is submitted.